Thank you. Good morning, Ms. Kavanagh. I understand that your clients they're not here, but they are able to watch the hearing on the live stream link.
Yes, most grateful, my lords and my lady, for that accommodation. That no disrespect is intended.
Of course not.
That the position, of course, is that they have the care of C.
Yes.
And they would have had to travel overnight. C would have had to been accommodated for the first night away from her parents.
Yes. Well, there's no any further explanation. We saw what was said, and or I saw what was said, and I decided that was the right course. And I think you may be in contact, or your junior may be in contact with your solicitor. So if we need to have further information, that will be easily supplied.
Most grateful, and yes, we have a line of communication, so I'm grateful. Thank you.
And the other thing to say is that the Guardian is not represented today. They filed a skeleton argument
Yes.
Opposing the appeal.
Yes.
Inquired whether they need attend, and again I took the view that it wasn't necessary. So they're not here, but obviously we have their position.
Yes.
We've had an opportunity, Miss. Just trying to work out where the judgment's gone. Is that your copy? No. I hope my copy of the judgment has arrived.
Put it in the core bundle.
It is in the core bundle, but I've taken it out of the core bundle.
Yes.
Maybe she put it
My lord, we have
maybe it's been
copies.
put. No. Mine's been written all over. Oh no, my clerk has put it back in. So we have read the judgment, the skeleton arguments. I've looked at some of the evidence. I think we're familiar with the issues. When I say we've read the judgment, Miss Kavanagh, it's obviously an exceptionally long judgment, and although I have read it, it may be that we will need to be taken to specific parts, in particular of the early part of the judgment, that either of you wish to refer to, yes. Because frankly, Miss Kavanagh, the judgment is so long that it's quite difficult to retain in one's head exactly all of what is said.
Yes.
In particular, the early parts of the judgment, and the structure is very clear.
Yes.
There's a summary of the issues, a very lengthy analysis, summary of the law. Summary is the wrong word. Exposition of the law, an even longer exposition of the evidence. And then from about paragraph 260 onwards, a section headed analysis. That's where, for my part, I've focused my thinking. So it may well be that we will need to be referred back to other parts of the judgment, as they are relevant. And I think Mr. Nouvelin in particular will want to do that.
Of course. And of course I'll bear that in mind. I'm grateful, my lord. My lords, plainly there is a fairly full, I must concede, skeleton argument. The word skeleton doesn't do it justice. I recognise it's fairly full and that there's a full narrative document. I will be cautious not to repeat anything set out in there, only to highlight, as your lordships invited me to do so, the evidence that we seek to take my lords and my lady to. But if I may, dealing briefly, you just to check the housekeeping first.
Yes.
My lords and my lady should have 3 bundles, a core bundle, supplemental and authorities bundle. You will have also had replaced within your authorities bundle the learning disability guidance from the Department of Health. The former version was in the original that you received, and your clerks have kindly put in the 2021 version, which is cited in
this.
It's not been put in, forgive me.
No, that's
it's
fine.
in loose leaf. I'm grateful.
Has it been provided electronically? Because I've got the 2nd of December authorities bundle. I haven't.
My lord is working electronically.
No, and in fact I will ask my learner junior to do that now and to email it through to your clerks. I'm grateful. Thank you. The position is that the replacement skeleton argument
Yes.
for the appellants should also be in separate hard copy form. I'm afraid the copy in the bundle is formatted in a rather bizarre manner, which would have led to a great deal of difficulty in reading. It's been fully anonymised, and the core bundle citations are in it for your own reading in due course. The position is in relation to the appellate's notice, of course, was issued on the 16th of September. Permission on all grounds was granted by my Lord Justice Baker on the 21st of November, and the stay, of course, followed to the determination of the appeal.
Yeah.
In relation to the appeal, of course, it's in relation to both orders, the care order and the placement order made on the 8th of September. And with your permission, may I maintain all 6 grounds of appeal, though I don't seek to amplify them substantially or in part at all today. In relation to the document that, upon judgment being handed down, a document was submitted to the court, which was effectively a document dealing with the stay, dealing with the law on amplification and clarification, and it was a document that then set out proposed at that stage grounds of appeal. My lords and my lady will find it in the supplemental bundle at page 51.
You want us to look at that?
Great.
Okay.
On page 2 of that document, so page 52, the court is His Honour Judge Lopez was referred to the case of Rie, and the first and second part of the analysis, whereby the court, of course, is able, should the court wish to revisit some of the reasons and provide additional reasons upon an application for permission to appeal, and that is in fact expressly referred to in paragraph 7, which you, my lords and my lady, will find at page 54 of that bundle. And it's suggested there that, of course, if upon careful consideration of the grounds the court wished to amplify, that was, of course, open to the court. There was then, of course, the court declined to do so, and the position is that the learned judge on that date and in his order at CB 53 indicated that he declines to deal with the application for amplification. Plainly, the approach that he had taken to that document was to consider it did invite amplification. Just bringing the position up to date, C remains at home.
Yeah.
K has, the local authority have not identified a placement for him, as we understand it, in which they propose to move him. The local authority has not given the formal 14 days notice of intention for his move in accordance with his final care plan. So that would indicate that the move would not be imminent. The learned judge has correctly recorded the evidence of Kay's social worker that the plan was for Kay to be outside of the care of the family home, and that's one of those early parts of the judgment. It may be helpful just to take my lords and my lady to that, and it's in the core bundle at CB 101, and if my lords have the judgment separately, it's paragraph 126 of the judgment. And it's in the early part. This is relating to the evidence of the key social worker for Kay, the allocated social worker, Ms. M. And it's set out there that her evidence is for Kay to be cared for outside of his family home. That is our plan, but it has to be ratified. We've had many meetings about the issue. And they've set out a little later, and the learned judge set out towards the bottom another quote setting out that they weren't looking at that stage for foster care for Kay, and they were looking for a residential placement, and that is an accurate recording of the position that was notified to the parties on the Friday just before the final hearing and then amplified in the evidence of the key social worker for that child at that hearing. Turning, if I may, straight away to ground one and dealing there with the position that we submit that the learned judge erred in his analysis of the treatment of risk.
Are you going to take us to the law?
I am, if I may.
Thank you.
I'm most grateful. Perhaps in the light of that, perhaps one starts in the law. That would be the best.
You've
place
given
to
us.
start.
Yes. You've given us.
There's a fairly full recitation of RESB in the skeleton.
Yes, you've given us RESB.
Yes.
The starting point's really I mean, that refers back to previous authorities,
yes,
doesn't it? Including
REMR is where if I may, take the court, because there's a fairly full recitation of RESB in paragraphs 16 and 17 of our skeleton argument, and you have the authority, but it starts at RESB starts at the authorities bundle page 14. But if we turn to REMR, which starts in the authorities bundle at 107.
Tab 8. Yep.
The position is that if we pick it up, the analysis of Lady Justice Butler Sloss on future risk, that starts at page 113, paragraph J, under the heading future risk.
Okay.
And that is a very...
So this is about assessing, this is about the welfare checklist.
Yes, this is the point at which, after a threshold fact has been made, how one treats at the welfare stage an allegation which has not been proved on the balance of probability.
Could you just, if you wouldn't mind, Miss Cameron, just for the benefit of all of us, just set out the propositions about how risk and likelihood are to be treated at threshold and then through to welfare?
Of course. So, in relation to the threshold criteria of Section 31(2) of the Children Act, there is either to be actual harm, significant harm suffered by a child, or there is to be a likelihood of the child suffering significant harm. Turning to the domain of likelihood, it's clear from the authority and helpfully summarised in RESB by Baroness Hale that the prediction of a likelihood of a child suffering harm must be based on a proven fact, the balance of probabilities that harm has occurred. So child A suffers an injury, then of course child A and B may have a situation where the court is dealing with their care proceedings on the basis that child A has suffered actual harm, but child B has a likelihood of suffering significant harm as a result of the injuries sustained to child A. It's that likelihood element that of course means that though child B was uninjured, the court has a proven past fact, first that an injury occurred, and secondly that it occurred to child B, and if the court determines that the perpetrator of that injury was a person who has care of those children, then the court has then got a proven on the balance of probabilities fact that there is harm to the child and the perpetrator was the carer. Moving to likelihood of the care of child B, if that carer is going to be a carer or putting themselves forward as a carer for child B, then there is a likelihood based on the proven facts that the child will fall into harm as a result of the care provided.
So the threshold's therefore crossed.
Thresholds.
And then when deciding what order to make, how does the law say the court should approach the question of likelihood of harm?
The law, as set out in both Re-B and Re-MR, is that in truth there is no distinction into the treatment of future risk of harm and the court making any predictions as to future risk of harm. And of course here, for our purposes, there are two areas on the welfare checklist where this arises. The first, in the Children Act, when the court is considering the making of a care order, it's section 1, subsection 3E.
I've asked for red books to be provided. Are you going to take us to?
Yes,
Okay.
going
So just-
building it
so-
up from
so-
the scratch, if we may.
So, just to make sure I've got it right, when the court is deciding what order to make under the Children Act,
Yes,
so that's an order in private law proceedings or public law proceedings for care proceedings, the court has to apply the welfare checklist in section 1, subsection 3 of the Children Act.
yes,
But when the court is deciding whether to make an order under the Adoption and Children Act, which includes an application for a placement order, authorising the placement of a child for adoption, the court applies the checklist in section 1, subsection 4 of the 2002 Act.
yes, my lord.
And the two checklists are similar but different in a number of important
They are
respects.
similar but different in many important respects, but in
Yeah.
respect of risk, the wording is almost identical.
Okay, so, but where the court is, as is often the case, and was the case here, faced with applications for care and placement orders together, authorities shows it's the placement order application which takes priority.
Yes.
So that means we look at the adoption checklist
Yes.
in section 1, subsection 4.
Although there ought to be a consideration of the Children Act checklist by the court in any event, but I recognise that it's supplanted by the adoption.
And in this case, it seems to me we can confine ourselves to section 1, subsection.
Yes, I'm grateful. In that case,
Okay,
then.
so I'm sorry, it's very long-winded.
Yes.
On my part. So let's
it's
go to
Adoption and Children Act 2002, section 1, subsection 4.
that. Okay,
The
so
version of
give
the
us a moment to find it. I think we've all got the 2002 books, so we're on section 1, subsection 4.
I have it around page 244, but I am in an older version. That's failing on my part.
It's after that. It's on page.
258.
Thank you.
I'm most grateful. I apologise.
Um,
And in particular, I draw attention to subsection D. So, of course, here where the court is making a decision about the welfare of a child, its welfare is paramount and it's considered under this Act throughout its life. And in particular, under subsection 1(4)(e), the court ought to have regard, and must have regard, to any harm within the meaning of the Children
Yeah.
Act which the child has suffered or is at risk of suffering. And harm within the meaning of the Children Act includes impairment of the child's health and development. And the definitions of health and development fall under section 105 of the Children Act.
Can I just ask a question? There is one difference in wording that
Yes.
catches my eye, which is that in the Children Act the word is likelihood, and in the 2002 Act the word is risk, or the word is likely, I think. Are the two synonymous?
In my respectful submission, yes. Because in truth, whether a child is at risk of suffering harm is it's not speaking in terms of, for example, possibilities of risk. It's speaking in terms of risk in our respectful submission.
Yes, well, possible risk is a difficult concept, but
Yes.
I suppose the question really is that likely is a difficult word in a lot of legal contexts. But in this context, I take it that it is not about a probability or some higher threshold than a risk that is a possible, foreseeable, and realistically foreseeable event.
real possibility
Real
is,
possibility,
is,
that's
what's
the-
usually said for likelihood,
Yeah.
and you say it's the same for risk.
It's the same, and it must be the same, given that there isn't, for example, an insertion of a word like possibility or some other caveat to the phraseology.
While we're here,
Yes.
just remind myself of the differences between the key differences between the two checklists. When you're looking at an adoption decision, the Act says, subsection 2, the paramount consideration must be the child's welfare throughout his life. Those three words don't appear in the Children Act
Yes.
definition. And then in subsection 4, the checklist, there are a number of differences which you say are important in this case,
Indeed.
not on the particular point we're looking at now, but in particular F, subsection.
Indeed. And of course,
1
C,
4F.
ceasing to be a member of your family.
Yeah.
But F and C are the substantive areas where there are differences. And indeed, throughout the child's life, it may be an obvious point, but it's beyond childhood in the Adoption Act. It's into your adulthood. And indeed, because this order, an order under this Act, can change everything, including your ability to call somebody a relative or inherit from them, as even in adulthood. And so those are fairly profound changes to a child's future. So going back, if I may, and I do root myself in a position whereby the likelihood or real possibility of harm is the same across both acts. The position is that it is, in our respectful submission, clear that the local authority in an instance where it's a public law case, or the person bringing an allegation, must first root themselves in a finding of fact or enough evidence to establish to the court's satisfaction that on the balance of probabilities an act occurred which would give rise to a risk of harm to a child. In this instance, it's an act of sexual touching between siblings at a time when they were young and in the care of parents who ought to protect from such behaviours or be alert to such behaviours.
It wouldn't have to be confined, though, Ms. Kavanagh, to that, would it? There could be findings. There could be a number of different findings the court could make, which would give rise to a finding of a likelihood of significant sexual harm.
Yes, I recognise that. But the court would have to, in any event, whatever that finding, make that finding on the balance of probabilities. With
There has to be a finding or findings. Yeah.
And turning then, if I may, just to the dicta of this court in Re MR.
Okay.
And back, if I may, to just so that I can follow that through from page 113. The court there, Lady Justice Butler Stoss.
Just remind us. I'm sorry, just to take. So in this case, this is post-threshold. It's a private law. It's a private law case.
Yes. And the question was the welfare of the child and the future placement of the child. And the question, of course, in those circumstances was similar to the exercise being undertaken.
Well, he says a private law case. Are you sure MR is a private law case? It all talks about threshold at the top in the head note. So, but it's a case in which the focus was on the welfare stage.
Yes, I do apologise. I think yes, it's a forgive me. It's a threshold case, but the focus is on the welfare stage, and the question then is the Children Act, section 1.3 is what the court was dealing with here.
Okay.
And it says it, of course, cross-refers back to the decision of the House of Lords then, and Lord Nichols, giving the clear guidance that is set out in Re SB, which we've looked at, which is that either turning over to 114, that the standard of proof is a preponderance of probabilities. The word likely meant a real possibility, so addressing my Lord's point of the interchangeable language. The question then arose as to what was required to establish such a real possibility. This is at that stage looking at threshold. The primary case made by this was a case of an allegation of sexual abuse, and it was therefore likely that the allegation was that at the welfare stage the court should account that it was likely he would go on to abuse another child in his care. The position going down to, if I may, D, by a majority, again cross-referring to Re H, the House of Lords rejected this submission on the grounds that the court must base its conclusion on facts, not on judicial or other suspicions or doubts. There was only a risk to the children if Mr. R had in fact abused the other child, in the absence of proof of that fact on the preponderance of probabilities, there was nothing to suggest that other children were at risk of harm. Following that through then to how that is addressed in the welfare stage, what this court was seized of, a distinction was attempted to be drawn by then Mr.
Newton, supported by Mr. McFarlane.
Yes, indeed. Ambitious argument. It was a distinction attempted to be drawn that that's not the approach that ought to be taken at the welfare stage. And of course, one can see as one goes down towards...
Well, it's the bottom of that page.
Bottom of that paragraph, that the submission and H, it's picked up as in our judgment, these submissions cannot be supported. They amount to an assertion that under Section 1, the welfare of a child dictates the court should act on suspicion or doubts rather than facts. To our minds, the welfare of a child dictates the exact opposite. And then her ladyship rooting herself in Section 1.3 moves into J, which is addressing item E of the checklist, which, of course, I respectfully submit for your purposes is the same as 1.4E of the Adoption of Children Act checklist. In relation to this exercise, if there is a dispute as to whether a child has suffered or is at risk of suffering harm, the task of the judge when considering whether to make any order, whether it be a care or supervision order or indeed a private law order, they must be to resolve that dispute. Unless this is done, it will remain in doubt whether or not the child has suffered significant harm or is at risk of suffering significant harm. And thus it will remain in doubt whether or not there exist factors which Parliament expressly considered to be of particular importance to be taken into account. Moving through, if I may, to the next paragraph, the court, picking up in the second sentence, the court must reach a conclusion based on facts, not suspicions or mere doubts. If, as in the present case, the court concludes that the evidence is insufficient to prove sexual abuse in the past, and if the fact of sexual abuse in the past is the only basis for asserting a risk of sexual abuse in the future, then it follows that there is nothing except suspicion or mere doubts to show a risk of sexual abuse in the future. Pausing there, it's our respectful submission that here it's not just simply an issue of insufficiency of the evidence, though the evidence was insufficient. There was an argument as to whether the evidence was sufficient even to embark on a consideration of the allegations by hearing evidence. And at an early stage in the proceedings, the learned judge determined that the evidence was not sufficient for that, so there was no consideration of the allegations, and the allegations were not before the court for the court to be able to...
When was that decision taken?
That took place, forgive me, I just must refer to the date in my skeleton argument.
And is it referred to in the judgment?
It is. I'll just find the reference in the judgment. This is a fairly early stage in the judgment, my lords and my lady. Yes. It's at paragraph 28 of the judgment, which you'll find at Call Bundle 63. It's the first reference to it. And it took place on the 16th of March of 2020. Right. That related to the proceedings for J, K and S.
Can I just remind myself of 28? That's right. The Guardian sought to argue at that stage there should be findings.
The Guardian for S.
For S, yes.
And
was
the Guardians...
Was it the same Guardian or
no,
not?
The Guardian for the boys, J and K, argued the opposite.
Okay. Oh, yes, that's right. And... Right.
So, in our respectful submission, we are still here in the territory as set out in the authority. And if I may just going back to the authority, and this was cited in our skeleton argument, and you'll see it in the section in Re SB, going back to 115 in the authorities bundle, the conclusion on the issue of welfare at this stage of section 1 subsection 3e is reached in the middle of paragraph C. To our, the submission being that a real possibility of harm in the past, then it must follow, if nothing is done, that there is a risk of harm in the future. To our minds, however, the proposition contains a non sequitur. The fact that there might have been harm in the past does not establish a risk of harm in the future. The very highest it can be put is that what might possibly have happened in the past means there may possibly be a risk of the same thing happening in the future.
And that's my Lord's point about the possibility of a risk.
Quite. And it may, in some cases, be forensically necessary to determine that. So, for example, a child who says she has suffered sexual abuse, the court may be looking at whether she requires a therapeutic placement which addresses her needs and from her perspective. So possibility or actual risk can be a feature that requires nuanced consideration in a case. We don't say it's wholly irrelevant, but we will say, and we do submit, that when one's looking at likelihood of risk of harm, it is not a matter to be taken into account if it only reaches a possibility. And I'll come to where I say that is in the law in a moment. And so just if I may, following this through, having reached that section 1(3)e in the middle of that paragraph of D, however, does not deal with what might possibly have happened or what future risk there may possibly be. It speaks in terms of what has happened and what is at risk of happening, pausing there to address my Lord Justice Warby's point. That is, in our respectful submission, how one grounds oneself in section 1, subsection 4e, because, of course, it speaks in the same terms, though it does not use the word likelihood as properly pointed out to me. Dealing with the fact that it cannot be justified to have a different approach, yes, forgive me.
Okay, I think
it's only repetitious. I'll move on
to
then deal, if I may, with Re J in the Supreme Court, which I didn't cite in my skeleton argument, but I found a fairly succinct summary of where the law rests here.
Okay,
and I wonder if that might be of use to you.
Where is that?
Authorities Bundle 171.
Okay, so this is...
My Lord, this is the case where, after Re SB, paragraph 49 was laid down at the end of Re SB, there were a series of cases brought before the courts to attempt to take that point up. Re J is the case that ultimately reached the Supreme Court.
I think you may have to put a few more of the blocks in place along the way. So you haven't cited Re B at all, and you have cited Re SB, and now we've moved on beyond Re SB to Re J.
Yes. Yes. Re B, of course, is I've taken it as
Re B is the case, the first case. It was still the House of Lords, wasn't it?
Yes.
The House of Lords, which is the principal authority on the treatment of the standard of the standard and burden of proof in family proceedings, and that's Lord Hoffman, binary approach, etc.
Yes.
That's quoted at length and built on in Re SB.
Yes.
And Re J develops a point left open in Re SB.
That point is slightly different in the sense that it is this. In the scenario in Re SB, Baroness Hale, albeit obiter at the end in paragraph 49, identified that what she had there was a case in which a child was injured in the care of two parents, and the court could not in that instance determine which of the two caused those injuries was the perpetrator. So the finding of fact on the balance of probabilities was the child had an inflicted injury, but it was the case that the parents blaming one another, or the court couldn't decide which of the two it was. So developed that there was a real a real possibility that either could have inflicted the injury. So threshold for that child was crossed, and for any sibling, because they were in that constituted household. The issue in Re SB had arisen that, of course, one of those parents, who had a finding of a real possibility that they were the perpetrator, had gone on to have another child in another relationship. And having done so, the question of threshold in relation to that child, how does one treat a person who has a finding that they are a possibility of being a perpetrator as opposed to a finding of fact? Now, it didn't arise for consideration directly on the point in Re SB, though the question mark is raised in paragraph 49, but it does arise in Re J, and the vast majority of the case is dedicated to that issue. However, looking at page 171 of the authorities bundle, and picking up Baroness Hale's analysis of the case law over as it's developed from Lancashire and B, Re O, Re H. Thank you. At paragraph 30, picking up on that which was said by Lord Nichols in Re H and Lancashire and B, that considering the likelihood of future harm for the purposes of here the threshold, the court had to act only on the basis of proven facts. Likely meant real possibility, and perhaps you could read that paragraph to yourself. 30 down to 31, and it's 32 that, in my respect, submission is a very helpful.
Which page are we on?
171.
All right,
Just give us a note. So you'd like us to read 30
to 32 and it's
inclusive.
32 that, in my respect, submission is a very
Thank you.
succinct summary of where you find yourself.
Okay. So this is Lord Nichols is being quoted by Lady Hale, and it's Lord Nichols in Re O, is it? It looks
to me like it is. Yes, it is. Reiterating principles that he'd already recited in Re H and Lancashire and B.
Okay.
Picking it up in our respect submission, it's the case that unproven allegations of harm cannot be taken into account, even taken into account, at a welfare stage for a risk analysis. And in our respectful submission, this is the root of where the learned judge in this case errs. I'll come in a moment to how he treats them, but he should not have been taking them into account at all in our respectful submission.
So you're effectively saying that he should have ignored and put out of his mind any allegation in relation to abuse between the children, between the older children.
For the purposes of undertaking a risk assessment as to the future risk of harm to C, I don't say that it's not part of the factual background of the case and that there may be features of children's treatment plans or therapeutic plans which
But
require
that's not
new...
this. But at this stage, when he's making the welfare decision,
Yes.
you're saying it should have been put out of his mind.
Yes, for
This
the
does
purposes of risk assessment.
This does present quite a lot of problems for all professionals dealing in these cases, because in this case we have, and we're going to look at it no doubt in a minute, we do have facts which were either proved or accepted, which could be taken into account
Yes.
in assessing likelihood of future harm.
Yes.
But in addition, there were other allegations which were not proved,
Yes.
and yet clearly were taken into account by the professionals on whose advice the judge ultimately relied.
Yes.
That's your
And
one way of looking at it.
expressly by the judge. and he does so in two places. So if we turn to how
Are we moving away from the law? Have we done anything else?
Sorry, I interrupted.
No,
You
no,
may
no.
want to complete what you're saying.
No, in relation to the law, no, I've reached a point where we say that
okay.
the court ought to have drawn, I accept the difficulty, but drawn an intellectual distinction at that point, and it recognised it could not utilise those allegations in its assessment of future risk for C, and set them aside for that purpose. The judge expressly addresses this under the heading, what type of harm might arise for C. So he expressly considers it is a type of harm that might arise for C, and that's in his judgment at, for internal reference, 315, but it's CB 190.
Is that paragraph 315?
315.
Is this where he's going through Lord Justice Peter Jackson's discipline?
Yes. Yes.
At the end of the judgment.
He is at the end of the judgment, and returns to this question under the express heading. First, what is the type of harm that might arise? And we don't, of course, cannot take issue that he identifies principally three types of harm, but the first one being an inability to provide predictable and reliable parenting, and the next being a risk of physical harm from K's behaviour. But picking it up towards the bottom of that paragraph, over the page at 190, in the middle of the paragraph, it starts, the court has made it clear that it has not treated the allegations that A, C, R behaved sexually inappropriately towards a young girl when he was a child, or B, the allegations that J and / or K behaved in a sexually inappropriate manner towards their sister, S, as she alleged, as proved, since the same have not been determined by the court. However, the judge does go on to, of course, recognise a potential distinction to be drawn with J's behaviour towards his adult mother, because she accepted that that happened. It didn't place it in issue before the court for proof. But we are here concerned with allegations of sexual harm by children to children. And however, the court's current view about the other allegations is that views about the other allegations made against C, J, and K is that the court finds relevant. The court seeks to, and the learned judge sought to, draw some distinction between the fact that because the parents had, he said, accepted in the course of their oral evidence that the incidents may have occurred, and indeed he attributes on to the parents then that they accepted therefore a risk of sexual harm. I'll come in a moment to show the court how they did not accept that, but even assuming that they did, the learned judge goes on to consider that, setting out here, whilst to...
Of risk, he accepts, he attaches weight to their acceptance of risk in their oral evidence.
Yes. If I take you to what they actually said...
Well, before you do that,
yes,
I interrupt
of course.
You say you're going to say they didn't do that, but if they did do that, if they accepted the risk, that's not the end of it, is it?
No.
In fact, your point is that is not the way, not the right
The law
approach.
doesn't permit the court to take anything said by somebody about a possible fact that may or may not have occurred and take it forward as therefore, even if you accept it might well have occurred or it did occur, it doesn't mean the court can go on to reformulate that as a risk of harm, because there is no proven factual element which is at the root of the analysis of likelihood of harm.
Is there a difference between a social worker accepting it as a real possibility without proof, the possible risk, or on the one hand, as opposed to the parents? Does the fact that the parents, the judge found, accepted that, does that entitle him to rely on that acceptance or not?
In our respectful submission, no.
There's no difference.
It was a distinction without a difference, because here what you have is, even, let's assume for a moment the parents did accept that there was a real risk of sexual harm from the boys. It's right to say that the court went on in its analysis of whether that child was at risk of harm from its parents, protecting against that risk. The court's analysis required required the learned judge to root himself in the law, and the law is fairly clear that absent a proven factual matrix underpinning an analysis of likelihood of harm, the court can't go on to rely upon it as a risk of significant harm to a child. So even if a lay person,
can I just clarify? You would make the same point in relation to the social workers. So social workers' reports are replete with risk of sexual harm. Do you say exactly the same?
I say that,
or is there a nuance there?
in a risk assessment by a social worker looking and challenging parents, it may be.
No, I'm talking about when it comes to the court's approach to that evidence.
Yes, the court. The use of language by lay people under professional of something being a risk when indeed the legal position is that it is a possible risk. It should be treated the same whether they are a professional or a lay person
When it gets to the court
by the learned judge. Because the function of the learned judge, of course, is to take all the information that he or she receives, attribute the relevance of that to the information that the learned judge requires, look at whether the person's in a position to assist the judge, and if it's a lay person, they may not be in as a significant a position, to be careful with their language as a professional. But the learned judge's function is to then take all of that and undertake a fairly clear exercise as to distill what are the risks of harm to the child. And when one's looking at that, one has to take it in those compartments in our respectful submission and analyse for oneself whether it reaches the sort of, forgive me for using this word, threshold, that it can establish, for example, a proven factual matrix, which the court can then go on to say.
Okay, but I mean, as has already been indicated, if the social worker's evidence is effectively full of reference to this risk of abuse or perceived risk of abuse, that is quite fundamental in terms of what the judge then does with that evidence, because the social worker's evidence, you might say, is completely tainted.
Yes, and indeed that's the approach.
If that's right.
And that was the approach taken in submissions in this case. But it's fair to say that the learned judge, of course, receiving that evidence must treat it with caution and apply caveat. And we are critical of the learned judge in our submissions in the written case, that the learned judge didn't address this, the fact that the psychologist and the independent social worker's evidence was littered with references to a risk of sexual harm from inside the household, namely from K and CR, who come in and out of the house, came in and out of the household.
It may well be a good idea at some point, if you just go through not all the judges' repetition of the evidence, but perhaps Dr. G and Moses, the social worker. But anyway, you wanted to challenge the judge's description of what the parents accepted.
Yes, if I may, just
can we start with what he did say about what they accepted in paragraph 300?
Yes, of course.
Because as I read it, you may not need to go to the underlying evidence, because his description was that they accepted that there was a possibility that C posed a sexual risk to RC.
Rather than take it there.
Which they believed to be small. And as to J, they accepted there was a possibility that he had sexually abused S, and a possibility that he posed a sexual risk to RC. So all in terms of possibilities.
Yes.
he doesn't record the parents as accepting that it happened or that it probably happened. So the possible risk, this curious concept, is, in this account of things, a risk which arises if it's true that any of these allegations are the case, but not otherwise.
My lord, yes. Perhaps just for your note then, if I give you the references, and I won't take you to them, if you do wish to look at where he summarises that evidence in the early part of the judgment in due course. So for the mother, it's summarised in his paragraph 221, CB 150.
221.
Yes. And my lord, for the father, my lords, my lady, forgive me, it's 239 and 240, and that's CB 159. And my lord has the formulation correctly summarised in paragraph 300, so I needn't take you to it. So care needed to be taken by a judge receiving evidence of that character, not to recharacterise it too highly, and here the learned judge failed to do that. It wasn't open to the learned judge to conclude on a proper application of the principles that there was proof of likelihood of future sexual harm from those persons to this child. And the learned judge was therefore bound by authority to reframe what he had heard correctly as a possibility of future harm. It's right also to say that the learned judge did not just treat it as a relevant factor under his identification of the types of harm for the purposes of my Lord Justice Peter Jackson's test in Re-F. He also brought it into account in his analysis of the disadvantages of being cared for by her parents, and my lords will and my lady will find that under yes, paragraph 299, and that's CB 184.
Yes.
And then leading on to the paragraph my lord has already taken us to at 300 and 301.
399.
9 is picking it, starting with the recitation of how to treat such matters, moving from what the parents said to how the learned judge formulates that as a likelihood.
It's 300.
300.
That's the passage my lord's just taken you to.
Indeed.
And also,
301 is a more generalised point about what a reasonable parent ought to do. But it's notable that the language of the learned judge here, despite the absence of findings that CRJ or K were involved in sexually inappropriate behaviour with their sister, in relation to J and K with their sister, the judge plainly goes back to revisit the the parents acknowledging the possibility, and therefore C, J and K pose a sexual risk to C. Yeah. So in our respectful submission, it's not...
it's the next sentence, isn't it?
Yes, yes, forgive me. The parents have reached that view as they told the court that they had. The court is entitled to take account their views and conclusions as to otherwise would lead to artificial position. However, the views of the parents...
That sentence is obviously key to your submission.
Yes. About
what the parents belatedly acknowledged. There's an ambiguity in the last phrase of it, isn't there? They did acknowledge the possibility that the same occurred. You would say they didn't acknowledge that there was a sexual risk. But it's not clear in that sentence whether that's the judge's conclusion or his characterisation of what they acknowledged. Either way, he goes on to use that conclusory statement as a basis for a finding about sexual risk, as one can see from paragraph 302, where he emphasises that the risk of harm to C is not limited to sexual abuse. So he's already found by that stage that there is a risk of sexual abuse.
Yes, my lord.
So that seems to be the stage of the precise nature of the reasoning isn't very clear, But he does move from an acknowledgement to a finding.
In our respect submission, he does. And he does so in two very important parts of the exercise. First, when starting to identify what are the risks of harm to the given child who he is now dealing with. And secondly, at a later stage, as he is bound to do when he undertakes the holistic analysis of the reasonable options for placement for a child before looking, of course, as to whether the only thing that will do for her is adoption. And here, this section of the judgment is a very central point because it's the disadvantages of remaining in her family. So the learned judge accounts it in two central and essential placements.
And that's a 300, 299 to 300, as you've mentioned. And when he goes through what I call the Peter Jackson discipline,
of course,
at the six stages, he doesn't go over that again. He just reiterates it, doesn't he? That's the 319.
My lord, yes.
Okay.
My lord, perhaps if I go through the exercise you've invited me to do of looking at the evidence, and for particular Dr. G and the independent social worker where he relies.
I mean, this I think is a difficulty for judges dealing with these sorts of cases and for all practitioners, where some findings are made. So the threshold document in respect of the other older children in the earlier proceedings included a number of findings which were agreed. But in addition, there's other matters which are not agreed and not proved, and yet taken into account by the professionals. And one can see that reading through the judge's recital of their evidence. It's littered.
Yes.
Dr. G and Ms. S.
Yes.
Particular.
I mean, if it would be helpful to my lords and my lady, rather than take your time now, we could perhaps provide you with a short schedule. Very quickly, I would have thought, because I have it in my notes, of all the relevant paragraphs, because it's difficult to navigate this judgment.
Just so we know we're talking about the same thing, what would that schedule be a schedule of?
It will simply be a schedule of the paragraph number and the pagination, and then setting out what the expert has said, which we would say is a summary of reliance on a risk of sexual harm to C. So where they have gone as high as saying it is a risk as opposed to a possible risk. And there are a number of sections of the evidence of Dr. G and the independent social worker where they rely upon it as though it is a risk. You, my lord, may have them because you've read the judgment.
I have read the judgment, but I haven't, as I've already said, read it obviously with the thoroughness that you have.
Of course.
I will do, but I haven't as yet. And if you think that would help us, then subject to Mr. Nuvoloni perhaps having the right to reply in some way, for my part, I think that would be helpful. I've relied on one. It was going to take one particular sentence. So that's paragraph 177 in the treatment of Dr. G's evidence. Yes.
And then perhaps 196 of the ISW might be another illustration.
I mean, there are lots. I've made a number of notes from Dr. G's evidence, but the first two sentences seem to me to encapsulate the problem.
Yes.
Dr. G indicated that she was aware that no findings had been made by a court that J&K sexually abused S, as she alleged. She agreed that this made it more difficult for the parents to accept that such abuse had taken place, although they made it very clear that they did not believe the allegations.
And then goes on in the next paragraph, at 178, to state in oral evidence that although she was concerned about the sexual risk to C, if she forgive me, it's jumped. Difficulty with iPads.
178?
Yes, forgive me. In the care of a parent, it was not the only cause for concern, so a similar analysis to the learned judge undertaking both in paragraph 302, as my Lord Justice Warby pointed out, and perhaps the point your lordship makes about encapsulating the difficulty for a parent when they're under scrutiny in a witness box about something that they have been open, they don't know if happened, they don't necessarily believe happened, and they think it's possible that it did, to then be criticised for not confirming that it is an actual risk to their child. And to go on to make up a framework and a care plan by which they are tested against whether they can manage to be that the child must not be alone with those individuals because of the risk of harm, including sexual harm. I recognise with K and with J it includes more than that, but it's a significant element which required much more care and scrutiny when dealing with a care plan for adoption which takes the child away from their family. And I mentioned that I would refer to 196 because this perhaps is well illustrated by the independent social worker in the way she treats this. Forgive me.
Yeah.
Yes, so 196, where she says, my concern is it's not just the risk of sexual harm, there's a risk of physical, emotional and sexual harm. And then the Guardian, which in
Just sorry, where is that in 196?
That's, forgive me, it's in the middle of the, in fact, 2/3 of the way down the paragraph. She indicated that her concern about Kay's behaviour was not just sexual. And of course, Kay is the only allegation against him relating to a sexual matter of relevance to C would be the allegation that S made, which is the allegation we are concerned with. But here, the Guardian goes much further than that in her written case. And if one looks at the paragraph 252 on page 167, my Lord's highlighting of the difficulty of the parents is only compounded by a Guardian saying in the second paragraph on that page, I am deeply troubled that the parents shared several times that they do not believe S's allegations. I accept that findings were not made in relation to allegations.
Sorry,
However,
where are you reading from?
Forgive me, that's the second paragraph on 167, 253.
Sorry.
Sorry,
No, my mistake.
Oh, it's 253.
I did not notice that additional paragraph number in my notes. My apologies. So 253, top of the page.
Thank you, yes.
Second paragraph, I'm deeply troubled. I accept that findings were not made in relation to allegations. However, the absence of findings does not mean that S was not sexually harmed or at risk of sexual harm, especially from the parents' perspective. And where...
Well, it doesn't, but it doesn't mean they were.
Yes.
I mean, to be clear, one can't blame professionals.
No, I don't.
From being approaching the risk from their perspective.
Yes.
But your point is that when this comes into the forensic context, it has to be treated very carefully.
And indeed, when the court is analysing that evidence of the professionals, and I appreciate I'm conflating other grounds, but it may not matter because it all arguably comes to the same thing, that in my respect, so shall just find the point, the learned judge didn't actually analyse the evidence of those professionals, those key professionals. He adopted it in full without caveat. And I'll take you to those. Yes, forgive me. Sorry, I was just moving across my notes to a different ground. Yes, so if I perhaps I'll take you to the references that are all in the similar area of the bundle. So it's CB 180, and in relation to the independent social worker, it's paragraph 289, and this is under the section of the judgment heading analysis.
Yes.
Yeah.
And the learned judge, of course, goes on to highlight and draw out some of the features of that evidence, which in my respectful submission is merely a recitation. There's no analysis there in our respectful submission. It's merely a recitation of those features that plainly strike the learned judge as important from the fuller recitation earlier in the judgment.
Did he do? You taken us to his acceptance and what Moses said.
And at the end, yes.
And you just, having shown us the passage at 255 from the Guardian, did he accept the Guardian? Yes.
So the Guardian, I'll give you the references of each of the ones he accepted who've fallen into this trap. Perhaps it's the quickest way. So the Guardian is 293 CB 182 and 294 CB 182. So 293 perhaps first.
293 or 292?
Yes. So 182, the learned judge specifically addresses the Guardian's evidence. In our respect, submission does not analyse it, but does the same thing, highlights sections that struck him And then at the end of that paragraph, as he does in the same language for each of the key three witnesses, identified that the court found the guardian to be a compelling witness. Her evidence was reasoned and measured. The court accepts and adopts her evidence. There's no caveat, there's no analysis as to whether there are all sections of the evidence which must be treated with caution, or indeed a look at whether every aspect of the evidence given by the guardian is relevant. And my lords and my lady will find that that exact phrase is used in the paragraph I took you to for the independent social worker. So for your note, I won't take you to each of them, I'll just give you the note, 289. Yeah. For Dr. Gill, for the key social worker of the child, which was putting forward a care plan for adoption, so a very important witness who does the same thing we submit, that's 290, CB 180.
Last sentence, 290.
Yes. And for Dr. G, the psychologist, that's 291, CB 181. And nowhere will the court find an analysis in our respectful submission of this key evidence which is adopted in full. Analysis is not recitation and not adopting. It requires the judge to engage with it, to consider and weigh it up as to whether there's other evidence that doesn't sit with it. As an aside, it's referenced elsewhere in the skeleton, but the guardian, of course, had made a fundamental error in her evidence. She had said that the child was visited virtually daily and was corrected in cross-examination. This is cited in the court's judgment, that the visits had dropped right off to once a week, and she hadn't been aware of it.
That's the guardian.
Yeah. So to have cited that line of cross-examination by my learned junior and the conclusion that she'd accepted she had not been aware of that, but then to go on to adopt all of her evidence without even addressing the, perhaps not that small point, but it's an important point.
That is a
Forgive me, I'm
point.
going on.
But on the question of risk, all of these witnesses you've identified took into account allegations as part of their assessment of risk, and in their treatment, their analysis of the parents' acceptance of risk.
Yes.
And the judge accepts it without criticism.
Or analysis.
Or analysis.
Or caveat.
Okay.
Now, my learned friend, Mr. Nuvoloni, King's Counsel, of course, draws properly to the court's attention the threshold facts and what was otherwise there for the court to consider future risk of sexual harm, and draws particular attention to the language in the threshold facts for C. So perhaps if I invite the court to just look at that, and it's Mr. Nuvoloni's paragraph 25 of his skeleton argument, but you will find the core bundle reference 216 to hold the threshold facts that were agreed for this child.
Yes.
Mr. Nuvoloni relies upon the language in paragraph 4.5, and so perhaps if we start with 4 itself before one goes to the sub-paragraphs. He relies upon it as a concession of fact. In our respectful submission, it is not a concession of proven fact. It is a recitation that the psychological assessment of Dr. H, dated the 11th of August, concluded as follows. And there is no dispute that it concluded as follows. And this is the issue, of course, that Lord Justice Bumby, the President in Rie, dealt with, this sort of loose language in threshold, which doesn't deal with sometimes what is a fact and what is just stating what somebody has said. Doesn't mean the conclusions adopted by the parents when they agree these facts. So in subparagraph 5, Mr. Nuvoloni relies upon this language, that the parents are currently unable to deliver the behavioural and modesty boundaries that are necessary to protect their children from identified risks in her familial home or in the wider community, potential child sexual exploitation. Well, that was an opinion of Dr. Hutchinson, and it's accurately recorded there. It doesn't mean that the parents accept the truth of each of the statements, nor does
what
that
statements?
That that at the time of the threat of the report, which would have been the 11th of August 2020, they were unable to deliver the behavioural and modesty boundaries necessary to protect the children from identified risks within her home. So that it's somehow suggested by the local authority, as I read it, that this concession of that there was some identified risks in the familial home is a concession that there were risks of sexual harm within the home. And I, on behalf of the parents, dispute that that is what it is.
So you say, just looking at the bottom of the previous page, this is just a list, a summary of what Dr. Hutchinson concluded.
And moreover, it does not specify sexual risk there in relation to the familial home. It specifies child sexual exploitation in relation to the wider community. And we know, of course, as my lord has pointed out, that there were other findings made, proper findings, that there were many risks in the home, including the behaviours of Kay, and previously when CR comes to the property, what, if any, behaviours he might have. So that is, in our respectful submission, doesn't save this point. There is no evidence or concession or factual matrix upon which this court, on which the lower court found it's sufficient to ground a likelihood of future sexual harm.
It's not very helpful to the judge for the local authority to say that they seek, in support of their contention that the threshold is satisfied, findings that Dr. H may reach certain conclusions. It doesn't take one anywhere.
It's wholly inappropriate, and indeed it's the subject of a criticism of a very lengthy Darlington judgment by the president of, as he then was, Lord Justice Mumby, looking at the question of this sort of loose language. If you're going to make an allegation, you make it and the parents either put it in issue or you prove it.
But the substance of it, presumably, is that the local authority was seeking findings that those conclusions were correct, and they were relying on the report as evidence to establish that. And that's the reality of it.
Yes.
Where that takes us, I don't know. But obviously, the local authority wasn't going to be satisfied with the finding. Yes, he said these things.
But if you see paragraph 6, which were actual concessions made of what we had not done well, and in fact had done badly, was that they were drawn properly as allegations which were accepted as and are findings of fact, that the children were exposed to that we allowed contact with adults. So those are properly drawn and conceded, but it does not rescue, in our respectful submission, this point about sexual harm.
These are very difficult, amongst the difficulties that arise, of course. What we're looking at here are findings that were made in the previous proceedings.
2020.
How those transfer onto later proceedings, it always causes, or often causes difficulty. Anyway.
And not least because they were so dated. All of the factual matrix that the court engaged in and proved on the threshold basis was dated in 2020 and 2019. This little girl was only born in 2021 and the court was hearing proceedings in June of 2022. So it was incumbent upon the court to look at what those facts were, what other facts may need to be found to deal with her situation specifically.
Yes.
And then go on to undertake a risk. What are the risks? How might those materialise? What can be done to protect her from them? And incumbent in that is a close analysis of C herself and C's situation. And that is,
this
we
is
say,
moving on to your next, isn't it? In due course, to your next grounds.
I'll just check if there's any other. Just to make the point that the relevant date for threshold is, of course, the date that the state intervenes. So the findings
That's the date on which
of the factual matrix.
on threshold.
On
But
threshold.
at welfare stage, the court can look at subsequent matters.
But the court here declined to do so on this element, but does make findings in relation to Kay's behaviour and the risk that might pose to a child in the household.
Okay.
Yes, so, and I do accept that those were as of the date of the judgment.
Have you now said all that you need to say on ground one?
Unless there are any matters.
Any more questions on
I'm
this?
grateful.
Okay. Right.
The same, the ground,
Substituted.
yes. The conclusion that there's been no change. Well, indeed, the
Well,
same.
hang on. Are you going to ground 2 now?
I was, but I didn't deal with it in that order.
Well,
in my skeleton.
I think, for my part, it's helpful to go on to ground 3 and
Yes.
4. 2 and 5 are really sort of subsidiary, aren't
They are, and they are caught up in ground 1 indeed, and
Yeah.
later in the proportionality point. So yes, if I deal with
they?
ground,
Substituted and corporate parenting.
yes.
Was there at any point a analysis or summary of the sort of help that would be required to be put into the family were C to remain at home?
My learned junior tells me that there was no document before the court which sets out exactly what the care plan would look like, alternative care plan, for example, or support. The sources of support that were to be put in seem to be agreed as between Dr. G and Dr. H, and Dr. H's analysis is essentially the root of that. I have, and I hope, tried to assist by pulling it all together in the skeleton argument as to what work was identified as necessary, and that is paragraph. Forgive me, I've dealt with it under 4 because it is
Okay.
because that's what was in truth missing. So you'll find it in paragraphs 43, which of my skeleton argument, our skeleton argument,
Okay.
which are the psychoeducational work, which was required for both parents at a frequency of once a week for 6 months. There were 2 years between that recommendation and this hearing, and that work hadn't been done. And that both Dr. Gregory and Mr. Hutchinson indicated that the development of a safety plan, which was effectively the resolutions model, which is
Just remind me of what that is.
so that is a model whereby if a parent has been found to be at risk of causing a child significant harm but denies it and maintains a denial, provided a support structure could be put around the family and the parent acknowledges something's gone wrong here, and you need to abide by principles, rules, boundaries, and you need a support network around you, then that's a model of a support package placed around the family to allow a child to remain there safely with other monitoring and support.
And this was a scheme devised some time ago now by
an organisation called Resolutions.
John Dumbleton.
Well, I heard-
Before your time, Miss Keller. And it's been used. It's used to support children to remain at home in those circumstances.
Yeah, sometimes after non-accidental injury, for example, where the parents can't bring themselves to admit it, but are willing to engage.
And this is what's proposed here, is it?
Yes, and
In outline.
In outline. But if I just deal with yes, Mr. Hutchinson perhaps gives the best illustration of the big piece of work, which would be perhaps the most intrusive, which is at CB 389 to 91 of the judgment. Court Judge 338.
CB.
Sorry, it's I apologise. I think I've made an error there in my notation.
Well,
I'll just check. So, sorry, that's in Mr. Hutchinson's report.
Yes. Do you want us to look at that?
Perhaps his oral evidence might be the better place to go because it's much shorter, better summary, and he explains
In the judgment.
it in very simple terms, and it's in the judgment. So if I just, forgive me, go to that. Yes. So the safety plan that he proposes starts at 163. So his initial
Right, are you talking about a
recommendation,
page number? or-
CB 120.
Thank you.
Initial recommendation is psychoeducational work with each parent. That it was accepted that the work done was not that, nor could it have affected change.
Sorry, which paragraph?
161.
161.
And this deals with a safety plan development, and the development of the safety plan would be there's an explanation of what it is at the bottom of 161, which we've just.
Can we just read 161 again? As I said, this is it's not at my fingertips, so I'd like to read it
CB
again.
120, yes.
Just read it again. Can we maybe read the whole paragraph?
And it might be helpful if one's doing that to do 162 as well, because they follow on from one
Okay.
another. My
Thank you.
lord.
Do you want to sit down, Mr. Kavanagh, for a
Of
moment?
course, thank you. Perhaps also 164, which is a resolution model. So, my lord, I won't take
Just a
you.
moment,
That's a
just a moment.
weekly
Just give us a
visitation
moment,
for
just give us
6
a moment,
months.
will you?
Oh, I apologise.
Thank you.
The report identifies that there's no issue between us. It's weekly for 6 months while you establish the safety plan. So weekly contact by the person responsible. And you will see from the summary that there would need to be, here, probably a professional outside of the family structure, who the parents could go to if there was a new friend or somebody coming into their lives to ask for advice and questions about. The learned judge proceeds on the basis that that sort of intervention is unreasonable for a local authority to provide and unsustainable. In our respectful submission, the learned judge fails here to engage in the warnings he gave himself in the legal section about recognising that where somebody has a static disability, such as a learning disability, which is unlikely to change other than perhaps marginal change through psychoeducative work, but here it wasn't going to change on ability to appreciate risk, that they may need lifelong support for the purposes of meeting their parental responsibilities. And it's support for the adult, not the child. It's advice to the adult. And it is the case that the Care Act, as I've set out in the skeleton argument, requires the well-being of the individual, the disabled person, to be considered for the need to identify their support needs. And the support needs include meeting their parental responsibilities to another, addressing their safety, and of course, maintaining their familial relationships. There needs to be at least 2 of those, and I've cited the 3 that would apply here. And what the learned judge does not do is engage at all with the adult assessments of the support needs of the adults. And here, in this case, it's very unfortunate that prior to the birth of C, there was a Care Act assessment which identified that the mother is fulfilling her own independence needs, looking after herself, and therefore didn't require any support from them. That required to be revisited, indeed, at the point at which the judge recognised that the court recognised that there was an issue as to the maintenance of support for the child and the family in the future, and to revisit the question of what the mother was entitled to and the father was entitled to support their own parenting, such that they are not at a disadvantage as a result of their disability. And of course, it's parenting with support. It is part of every aspect of a disabled person's parenting. If even I give the example in the document, if one has a physical disability, one might have carers or PAs there to undertake care of your children or do the cooking or assist in lifting them into bed or picking them up, but one might be directing it as the parent and speaking to the child, communicating with the child, parenting and making the decisions. So carer support is part of being the child of a person living with a disability. That's part of this child's genetic inheritance. It is not in our respectful submission engaged with, and it was not, the fact that it may not be a negative was not engaged with in our respectful submission. And here one has the court not, of course, properly identifying that one has to ask the question, is the support such that it effectively substitutes all of the parenting and somebody else is parenting the child? But here, Dr. Hutchinson was not identifying that there were many aspects of the parenting function that required support. He had specifically identified one that would not change, and that was the ability of the parents to identify risky individuals.
Okay, just to turn that round.
Give me.
Dr. Hutchinson's evidence was, just to invert it, that they didn't require help with all aspects of parenting. Is that right?
Mm-hmm.
But only that they would permanently need help with this aspect.
Yes.
Or some aspects.
And indeed, he'd added another element of support, which was psychoeducative work, because he recognised in both parents a potential to understand more about sexual abuse and to understand and to develop their understanding of sexual risks. So there was room for growth in one area, but it was common ground between Dr. Hutchinson and Dr. Gregory that in this area the safety plan would be necessary and somebody else would need to be contacted. Now, my lord in the Court of Protection has approved, no doubt, in the former life, care plans where one has a young person or an adult who is unable, for example, to make decisions about or lacks capacity to make decisions about their contact with others, but, for example, may have capacity to make decisions about consenting to sex. And therefore there is a very careful balance and plans drawn up as to how to work with that person to allow a screening or a checking of the persons that they're developing a relationship with to ensure that they're given the right advice and guidance, and risk assessments, if necessary, can be undertaken. Children in care, of course, do have an intrusive element to their lives. DBS checks are undertaken on every person they spend an overnight with, if that's not the foster care or the family that they are placed with. And so there are, of course, intrusions and checks and balances, both from children's and disabled adults' perspectives, which support care needs and do risk assessments. And so the question in our respectful submission was the court ought to engage with why that would be a substitution of parenting per se. especially in circumstances where the mother was meeting the needs of C to a very high standard, such that it was not even required that she had a nursery placement. The support they'd already put in place had been set aside. And it was recognised that until she was peripubescent, it was quite likely that the parents could meet all of her needs, say for this area. And the question of how they managed teenage behaviour was a real issue, and developmental advice and psychoeducation was going to be required at certain stages. And Dr. Hutchinson had identified that you might need to repeat work with them at different developmental stages to remind them, not least because of some aspects of the mother's working memory. So central was it to the question of whether the child could remain in the care of her parents, as it required in our respectful submission a particularity which is unavailable to you in the judgment, my lords and my lady. And if we on behalf of the parents can't find it, and we were present in the hearing, in our respectful submission, it is unacceptable for that to have led to a conclusion that a child can't live in that household for the rest of her life. Because, of course, what was required under the Adoption of Children Act, which is the primary checklist here, was not just consideration of this little girl now, or indeed when she was peripubescent and 8, 9, 10, 11, but to look at her at 14, 15, 16 throughout her life. And therefore to look at the household and how it would be constituted at those stages. What would be the pressures on the household? Would it be the same as it was before?
Well, the way that the judge approaches it, as I read the judgment, or so much of it as I've managed to grapple with, it is that he says in paragraph 297, there's a unanimous view amongst the individuals or organisations he names, the local authority, Miss S, Dr. G, and the Guardian, that the level of intervention in the long term is not reasonable, sustainable, or in Charlotte's C's welfare best interests.
Yeah.
3 different things: reasonable, sustainable, or in best interests. So he's essentially relying on the evidence of those he identifies, plus the contentions of the local authority, as the foundation for that conclusion. So in that sense, we know why the judge reached that conclusion. He's relying on what those witnesses have said about it, and he accepts their evaluation. What's wrong with that?
I earlier said I was looking to another ground of appeal when I looked for the references about those 3 witnesses primarily, but also the social worker, because there was no scrutiny of that evidence or analysis. What it was a repetition of some features of the evidence that struck the judge without any analysis as to whether it was correct. For example, here, the issue of the Guardian's mistake about the nature and extent of the visits is quite important. The Guardian had gone into the witness box assuming it was daily visits and was wrong about that, corrected in the witness box, and recognised that actually for some years, for about 18 months, this child had been seen once a week. And the Guardian drew no distinction between the fact that Kay was receiving an educational support provision called Stepping Stones and another provision, which came 4 or 5 times a week to try and draw him into education, try and encourage him to go. And so yes, professionals were in and out of the house, but one was required to look at what the parents were requiring to support their care of C, because C was going to be the child who would live in the household beyond Kay for a long time into her childhood, and by the time Kay was of an age where he would be an adult, she would only be 3. So in the circumstances, it was necessary for those professionals to be more particular, and the judge to identify what it was that was a full substitution of parenting, or which features of parenting were being substituted, and how that in and of itself would be against the child's interest. But what happened in this judgment is, in our respect submission, there's an adoption of the evidence as a whole, without caveat consideration of detail or criticisms of it, a failure to engage in the case being run by the parents about that evidence, and by adopting it, those sorts of summary paragraphs that my lord has taken us to is the manner in which the court justifies a conclusion and a finding that the parenting would have been so substituted and intrusive that it wasn't in her interests.
Well, so that sentence would be acceptable, wouldn't it, if it's the case that Mrs. Dr. G and the guardian identified the level of intervention they were talking about and said, in their opinion, it was not reasonable, sustainable, or in C's welfare interests.
It would not be sufficient in our respect submission to undertake the advantages and disadvantages detailed analysis required for Re-G, for the adoption. When one's looking at adoption as a care plan, one needs to undertake a holistic evaluation of the advantages and disadvantages of each realistic placement option. And that, in fact, requires a high level of scrutiny. And forgive me, but to borrow the language of Lord Justice, forgive me, Peter Jackson in Re F, it is sorry. Yes, but perhaps if I take you to it. Forgive me, I've just lost the page reference. Yes. So Lord Justice Peter Jackson, I'll just give you the paragraph numbers. So paragraphs 27 and 28 of the judgment in Re F, scrutinising the evidence in that case on
26
the facts.
and 27, did you say? What paragraph
27 and 28,
Sorry.
and that's AB 75. I needn't take you to it, but of course, it's an exercise this court's well familiar with. You really need to have, and he uses language of a quality of evidence to justify the very extreme order. So it must meet, in Lord Justice Peter Jackson's phrase, exacting standards because of the nature of the order. And so the evidence really needs to be treated to, is it really bad enough to justify the remedy of adoption in truth? And then that's a phrase that was used by Lord Justice Peter Jackson. So
I think it would help me to just take one example, can we? So pick one, Mrs. Dr. G or the guardian.
yes.
So where do they express the view which he summarises in 297?
Perhaps
Could you show us one of those to illustrate?
the Guardian's
or
perhaps the fullest.
illustrate why you say that is insufficient.
Yes, of course.
So the guardian is
Yes. So
guardian opined.
yes. So perhaps the
What,
Guardian.
244 onwards?
It's 165 CB 165, and it's 251 onwards.
Okay.
But
So now is this the judge summarising
this
the
is
guardian's
the
report?
cut and paste from the report, it seems. But then there is a helpful. It continues on.
Okay,
In this report, I'll just take you to the headlines. This is the closest one gets to a suggestion of what is actually needed on the ground or happens in the judgment in our respect submission. So in 251, the local authority must complete almost daily visits to ensure her safety, and that the local authority must complete almost daily visits to ensure her safety
Where are you
and
now
welfare is
reading
not
from?
compromised. This is 251, close to the bottom, third paragraph up. Regrettably, then the local authority, then it is for these reasons, going from the bottom up. Of 165, forgive me, page 165, 251, the judgment. So the Guardian identifies that almost daily visits were being completed. That's where she started in her report. Not accurate, and we'll come to it in a moment, but that's where she started. She then goes on to what other support over the page. Just while I'm here, in 252, the second paragraph, there's the reference to effectively meeting children's needs until prepubescent. I made earlier reference. The judge picks it up later. But moving further down, over the page to 168, if you go to her paragraph 254, second sentence, C is receiving a significant level of intervention from the local authority to ensure her safety and welfare is prioritised and she is not harmed, average of 4 visits a week, and then moves on in her oral evidence at 170. To sorry, I'll just find the reference.
So that's just wrong, what the Guardian said about that.
Yes,
is it?
and she
And
makes
where does the judge acknowledge that being corrected?
So it's at 172, paragraph 261. Halfway through the first paragraph, the Guardian indicated she had not been made aware that the local authority visits to the family home in respect of C had been reduced over time, and she stressed that the local authority involvement with the whole family, including in relation to K, had remained high. And the Guardian had, in her evidence, you'll see a little above that, suggested that the safety plan involved a quite high level of care, and it over. The Guardian then, moves to analyse that at 174.264, reciting that there was a high level of intervention. And again, no in-depth analysis of what that is, or indeed any. And in our respectful submission, the court would struggle to find. And that's the best quality you have of what is said is going to be required going forward. And in our respect submission, it just doesn't address it. There is, of course, a reference to what's going on now, that is maintaining her safety, and that was in error. But the learned judge does not pick that up in his analysis. He adopts, as you recall, I hope, the Guardian's evidence in full. And the Guardian was working on the basis that there was a high level of intervention. In fact, for K, he was seeing somebody 4 times a week sometimes.
There's a question of how relevant that is.
To see. And asking himself, and this is where in our respect submission a key error occurs. Learned judge properly looking at the history to identify likelihood of future risk to C, but does not then deal with C. He deals with the history and the difficulties that the other children have faced, but does not go on to distinguish the early life experiences that C had for the first 18 months, which were settled, securely attached, and well cared for, and does not look at whether or not her experiences would necessarily past would necessarily repeat. It is without detail, particularity.
Yes, it's an assertion.
And that's what all the evidence of the experts and professionals.
Could you just take us to Dr. G?
Yes, of course.
What Dr. G said about
Yes,
this?
of course.
So what I'm looking for is what
Yes.
the summary, the detail of the view of Dr. G summarised in the sentence in paragraph 297 that we looked at a few minutes
The
ago.
substituted parenting.
Not reasonable, sustainable, or in C's welfare best.
Dr. G's evidence is, her oral evidence starts at CB 125, but this section is a little into it. Yes, so paragraph 176 at CB 128. agreeing that there had been no reports of ability to meet C's needs. But then moving on in that paragraph, observed that they seem to be having a significant level of intervention in respect of the care for C, high level of visits to the family home, large number of professionals working with the family. And then when she goes on to look at the safety plan, at the bottom of that paragraph, recognition that the work done, as advised by Mr. Hutchinson, the work undertaken was unlikely to have made the difference because it wasn't the right work. And it's unsurprising that their views hadn't changed. And then in the next paragraph, looking at the safety plan.
It's paragraph number now,
So
please.
177 in the middle. She accepted the need for safety planning as recommended by Mr. Hutchinson in his report of August 2020. And over the page, again accepted that at the bottom of the paragraph of 177. In terms of the high, so her reference to a high level of work, I've already taken you to, high level of intervention. It may be
just
that
show me again where that was.
that was, give me
176, high
Yes,
level
it
of
was.
visits, significant level of intervention.
yes. Now the language
Lines,
of
5
substituted.
to 9.
Apologise.
Seem to be having
Yeah.
a significant level of intervention in respect to the care of C, in the sense that there are high level visits.
The language of substituted and corporate parenting comes from the Guardian.
Yeah.
So perhaps if I give me
I mean, you haven't yet shown us, I think, anything where Dr. G said it was that level was not reasonable, sustainable, or in C's welfare.
But that actually, as I understood it, not said by Dr. G, it was said by the Guardian, and that is her 174, paragraph 264.
Sorry.
She deals with the level of intervention. She deals with longer-term weekly visits from a local authority would not, in my view, be enough to reduce the risk, albeit that that's not been in place for 18 months. This is the middle of 164, and underneath, and that's a quote from her evidence, and she brings in there in the middle of that quote, in order to keep C safe and meet her needs, substituted parenting.
That's the Guardian.
Yes,
Okay.
and she then goes on underneath that to deal with the issue of whether it's sustainable. So where it goes into normal text, Guardian accepts, then the next sentence, however, the Guardian repeated her opinion that if C were to remain in the care of the parent, she would require a very high level of professional intervention in her life, and that the family throughout her minority, which was neither in her welfare interests or in the longer term sustainable.
Yes.
So
that's the
that's
Guardian. Yes,
yes,
the Guardian said it, but where did Dr. G? What the judge said was that the view of the local authority, Ms. S, Dr. G, and the Guardian, that such a high level of intervention in the long term over the next 6.5 years is not reasonable, sustainable, or in C's welfare interests. Now I'm satisfied that the Guardian said something to that effect,
Something to that effect.
but I haven't yet seen in the summary. Of the evidence Dr. G,
my understanding is that Dr. Gregory goes close to saying that it's high level of intervention and the safety
well,
plan.
she's saying there is a high level of intervention at the moment.
But mind,
Okay.
there is
All right.
no.
Well, maybe come back to that. And
Well, if
similarly, I'd
I
like
may
to know
have
what.
overlooked it, but my understanding is this came from primarily the Guardian,
Yeah,
and
well,
that Dr. Gregory, who was assessing the parents, of course, not C, so it wouldn't necessarily be Dr. Gregory. She would say what would be needed
Okay.
long term for the parents to undertake the work. C,
the
of course, didn't
intervention-
require a psychological assessment from
No,
an
the
officer.
intervention was going to be for the parents.
Yes, it was. To support them for their disability, their disadvantage. And indeed, if one did drill down to what this safety plan looks like, it's the parents having meetings with professionals at times, or perhaps professionals screening, checking, undertaking a safeguarding check, or indeed meeting with a new person who's introduced to the family and shall see to be taken out in the future if she's going to be, or he is going to be an important part of her life. So these are interventions for adults. They may impact on a child. I don't say they wouldn't, but it was incumbent upon the court to undertake more scrutiny than adopting language. And the difficulty we have finding these references in our respectful submission suggests that there isn't the sort of care taken to identify what substituted parenting here for C looked like and how it impacted on her now and at different stages of her development throughout her life.
Okay. Well, as we weren't able to find any in Dr. G, it may well be that Mr. Nouvelani will be able to find something.
Independent social worker.
Can we look at Ms. S? So that's at pages, paragraphs 185 onwards of the judgment.
Yes. Now,
So this was filed during the occurrence of these proceedings.
was, and it was initially it was a PAMS assessment as opposed to a full parenting assessment, and
Recommendations are at 192.
yes, it's in the body of her report, at CB 136. Couldn't identify purposeful work to put them in a place where they could set emotionally appropriate boundaries or emotionally attuned parenting. Forgive me.
Well, there's a reference to extensive intervention.
There is, and there's
the top two paragraphs of that page.
Yes. There is a reference
also at the
to
end,
134 at CB 134189. Because forgive me, that's again another reference to work, and that's
I think it's actually right at the end of her evidence, on 200, paragraph 200, on 140.
yes.
Where 6 lines up from the end, she
Yeah.
opined that the parents will not be able to do so without continued involvement and intervention from professionals.
Yeah. And identified a little further up there that the child would need to be safeguarding from all risks. That's a rather large statement. Though she does identify some of those risks, it includes, of course, D in that paragraph, which is the risk of sexual harm. And risky individuals are defined by this witness as including K and C are at 198. So when she says risky individuals, she does mean the brothers. So in our respect submission, I don't say that there wasn't in each witness's evidence it touched upon as to what that would look like for the child. But what there was not, and there was not in the course of the oral evidence, a look at how that would be experienced by the child. So what are we talking about each day, each week? Who's that for? How would that relate to this little girl? How would she feel that as she grows up? There was, and we acknowledge, a discussion, certainly by the Guardian, in part by the independent social worker, that weekly visits quite high even for a child in care. That's normally 4 to 6 weekly, and that would be intrusive. And that's not something that we shy away from. That is the case. But it isn't experienced by the parents as intrusive. That was the evidence of the mother, that she had indeed, and the support that was being offered at this stage was not necessarily the support that would be required as the child grew, or if and when, given the care plan was for the removal of K left the household. And so in those circumstances, it was necessary, we say, for the court to actually take stock and say, well, how would that need to continue weekly? It certainly might need to continue weekly for the first 6 months, because Dr. Hutchinson's evidence was that you'd need the weekly visits to set up the safety plan. But once the safety plan was set up for that purpose, it may not be necessary. Don't say it wouldn't necessarily have been important for other purposes, but that was the exercise that the learned judge, and indeed any of the professionals, failed to do.
But weekly visits isn't substitute parenting, is it?
In our respect for submission, it doesn't come close. Especially in circumstances where for 18 months this little girl had not left her mother's care 24/7. She hadn't even been to nursery because she didn't need it, because she was getting such a high standard of care. And I recognise that there would be challenges ahead, but it's right to say that none of the visits had produced concerns about the parenting she was receiving. There were concerns, quite properly and set out well in the judgment, about Kay's behaviour from time to time.
Okay. Well, now have we ranged over grounds 3 and 4?
And indeed, we've appeared to have, because they come under it, grounds 5 and 6. If I just check my note, I may have in fact be in a position whereby I can rest on my written case. I've been going quite a while, and I recognise I have a full note in any event.
No.
Yes. So, indeed, having just looked through, my note is fairly full, and my written case,
for our
so
part,
I
we
probably don't
think
need to.
we've covered the remaining grounds in our discussion. So thank you very much.
I'm very grateful.
Thank
And I can assist further.
you. Thank you. Yes, Mr. Nuvolady.
My lady, it may assist if I start with what I hope I found in terms of Dr. Gregory and Dr. Hutchinson, so Dr. G and Dr. H. It's paragraph 178.
Okay.
And that is at page 129.
Yeah.
That starts Dr. G.
Shall we read one?
I'm great.
Shall we just read it?
178.
Yeah.
178, my lord, yes.
So this is about. Are you drawing this to our attention in riposte to the inquiry as to where was the support for the judge's conclusion in paragraph 297?
My lord, yes. The suggestion that it was only the children's guardian who'd raised the issue of statutory parenting. There was clearly reference here from Dr. G that there needed to be delegated that role to a third personal body to ensure that C was safe in the care of a parent. That is some 12 lines down the roles.
That's Mr.
Yeah.
And that was agreement between Dr. G and Dr. H.
Okay.
Yep.
And there are further points in that paragraph, my lord, my lady, that cover the issue of the extent to which support is required. Now, perhaps, if I may come back to that in due course.
Okay.
Do my lords, my lady, have any particular point at which I should start or address to assist the court?
Well, it would help us, I think, if we. I mean, it's up to you. Take what course you want, but obviously we're focusing on the particular points that are raised in rounds 1, 2, 1, 3, 4, and 6.
Well, my lord, if I may, just as a precursor, the issue of threshold in care proceedings is clearly significant. The court can't make or even move on to consider the making of any public law order without it. And in this case, we have an agreed threshold. That's the factual basis upon which the court goes on to consider welfare. And it does that because Section 31 requires thresholds to be crossed, either following judicial findings or acceptance of an appropriate.
The court isn't confined to the threshold in identifying the factual basis for its ultimate decisions, is it?
No, but what we're being told today, my lords, is that this set of concessions by the parents is almost concessions without prejudice to the threshold. That is the factual matrix that the court has, which allows it to move on to consider issues of risk and welfare. Without it, it can't. And we say it's significant and relevant, the wording of that threshold, accepted by the parents as it was, accepted by the court to reflect the gravamen of the concern. And so it can't be just simply put to one side or dismissed because it hasn't been the result of a judicial fact-finding exercise. It's replaced the judicial fact-finding exercise. It's provided a factual basis, referred to in Re H&W, that is the first stage in considering whether the threshold is crossed and then moving on to consideration of welfare. And so that's why the local authorities say it's relevant and significant. Because it's not to be forgotten that the parents in this case were accepting of a care order. That was their primary position, was that we want C to stay in our care, we will do it under a care order. And of course the court can't make that care order without threshold being satisfied. And so we say that it's important that when this court looks at the judgment, it bears that in mind, that the parents have made concessions. And it is not just the learned judge's assessment of the parents' evidence before him, and also, of course, what they said to the various experts. It all plays in, as my lord has indicated, beyond the simple crossing of the threshold into consideration of what order should be made. Because, of course, the court is confronted with the no order principle, first of all. Just because the threshold is crossed does not mean there needs to be an order. And that's what this judge, we say, in analysing, assembling all the evidence, and he has a, as he terms it, a plethora of evidence about these parents and their ability to care, to see. And it's that he weighs into and scrutinises with his analysis. And we say that he does that in detail. It might be said that there is so much detail that it is sometimes perhaps difficult to pull out the analysis, but that is not to say that there isn't the evidence before the court. He sets it out in several hundred paragraphs how much evidence there is. And the evidence, we would say, all pointed one way. There was no argument that basic care was being provided to C. There was no argument that that was being done with support. And when one looks at paragraph 178 of that judgment, there seems to be no issue between Dr. G and Dr. H as to the fact that these parents could not ensure C's safety without their parenting role being delegated to a third person or body. And if one carries on reading 178...
Well,
I mean...
parenting role, you mean that aspect? They were unable to ensure the safety of the children without... And that role would have to be delegated.
As I say, it's accepted by the judge, it was accepted, I think, by all, that the basic care being provided to that young child was clearly good enough.
I mean,
Of course,
you suggested a moment ago, unless I've misunderstood you, that the parents were requiring support in what they were doing at the time, but I can see the parents were managing, as you said.
With
the
C.
With
With C.
with C. And what seems to be recognised is there was, by Dr. G, that there was a high level of intervention. Of course, weekly visits, and it clearly wasn't daily visits, that was clearly a misunderstanding on the part of the guardian. Weekly visits it's a high level of intervention. The learned friend has rightly accepted that under supervision orders or normal interactions it would be far less than weekly. But of course the court at this stage is dealing with a young child who will, in the course of her development, demonstrate new and varied needs which the experts gave evidence that these parents could not meet or would not be able to meet without that level of support.
Well, just what level of support are we talking about? What was the level of support which the experts were saying, or your evidence, local authority evidence, was saying would be required? Weekly?
Well, in a sense, that's the difficulty, because at that stage in time, with C the age she was, weekly was clearly allowing the parents to provide good enough care. Mm-hmm. But if one looks at 178, paragraph 178, this is Dr. Gregory's evidence, Dr. G's evidence, I do apologise. Mm-hmm. 10 lines from the, in addition, Dr. G opined that given the mother's cognitive deficits and the mother's difficulty in recognising her own emotions and those of others, she is likely to struggle as Charlotte develops.
C develops.
C develops. Again, I apologise. And of course, my lord, right at the very beginning of this hearing, focus was rightly placed on the welfare checklist under the Adoption Act, Child and Adoption Act, mm-hmm. which specifically expands the consideration throughout the life of the child. And of course, what the judge is being confronted with is a moment in time where a decision has to be made. The evidence before the court is, yes, care to this stage is good enough. But the court is then confronted with, well, what will happen for C as she develops in the care of the parents? That is what he does when he takes his analysis through the advantages and disadvantages of parental care, foster care and adoption. He does that over the course of the child's life.
Okay, but that passage goes on to talk about the care Carl requires, which is not necessarily the same.
No, it isn't. That's clearly right. They're two distinct individuals. The reality on the ground is, of course, that Kay was in the household.
Yeah, he's not going to be there. Is this right? The plan is for him to be moved, and you haven't been able to find a placement yet. Is that right?
The plan, whether that's residential or more akin to independent living, there is clearly going to be anticipated an ongoing relationship between Kay and his parents. And so it's not a plan that he's simply going to be removed.
How old is Kay now?
Excluded.
Remind me.
16.
Okay. Are you looking? Is the local authority looking for placements? Placements are hard to come by, residential placements.
They are.
So he may be placed quite a long way away, or that may be a factor.
He may be, if residential is found and identified as being suitable, given the relationship with the parents. It may be that the assessment of his needs leads more, as I say, to independent living, which may be closer to the parents. We don't know.
But not in the home.
That's certainly the plan, but of course, given the child's age, that will largely depend a lot on whether he wishes to engage in that plan and live away from his parents. So I don't seek to simply dismiss the parents' ability to care for C because Kay is in the house. It's separate and distinct. But it's unrealistic and artificial not to recognise what home environment the mother and father put before the court to consider, to weigh up those advantages.
So the home environment that's envisaged is that in the medium to long term, and possibly the short term, Kay won't be there, won't be living in the house.
Well, that's the local authority plan. That doesn't necessarily, my lord, of course, mean that it's a plan that will be affected for a child rising 16 and developing his own life. He may make his own decisions about what he wants to do. Those may mean he has to stay with and wants to stay with his parents.
Well, yes, but there are steps which can be taken to ensure that he isn't when he's an adult.
Well, the steps would require consideration of either supportive or encouragement, or indeed injunctive orders to prevent a child.
Was this part of the judge's reasoning?
There's no consideration simply beyond the plan of the local authority, which was that.
So the basis is that Kay will not be in the house. You're pointing out problems that may happen down the line, but that doesn't feature in the judge's
and he
reasoning
still
at all.
concludes, and so do the experts, that the parents, as C develops, won't be able to meet her needs. In this paragraph, it goes on to indicate, and indeed before that point, that there may be increased difficulties for anybody caring for C and K. But what's highlighted there, I would submit, is that the difficulties arise simply in caring for C in the long term.
Well, the reason I raised the point is that that's not necessarily how one reads the paragraph, because of the way it goes on after referring to struggling as C develops, immediately to refer to K.
Well, my lady, if one starts with the line third person or body, Dr. G was clear that she agreed with Mr. H opinion. Further, Dr. G agreed. Mr. H, the view of the family was seen by their community as being vulnerable. She also agreed with Dr. G that in view of the mother's significant cognitive abilities, those relate to the mother's ability to care for C with or without support. And what's being indicated is that they require such a level of support that isn't going to be in C's best interest, doesn't accord with her welfare, and that is what the Guardian also gave evidence about.
I fear, Mr. Nuvoloni, that it's very difficult to evaluate essentially just exactly how the judge dealt with this when he simply recites the evidence. It looks to me almost verbatim, certainly in enormous detail, both from the written reports and the oral evidence. I mean, it's very difficult. Both of you have struggled, and for my part, I've struggled to try to find exactly when he's talking in his analysis at the end of the judgment. He refers back to the judgment. His summary of the evidence is very difficult to see exactly how he does it.
Well, clearly in this section, the one we're looking at is simply that recitation of both reports cut and pasted into the judgment.
It is.
And then the judge, and then the evidence.
And sometimes it is dictated more or less word for word what the witness seems to have said.
And it's fair to say that usual criticism in this court is of the shortness of judgments and the lack of detail. And this may go too far the other way, my lord. I accept that. But the fact is, it does set out all the evidence that the court had before it in this section. And when we turn to the analysis section at paragraph 268, the judge does pick out, we say, from that evidence, both written and oral, what he bases his analysis on. Dr. G, we would say, is dealt with at paragraph 291.
Yeah.
It starts, the court has also had the benefit detailed comprehensive psychological assessments of both parents by Dr. G. Lengthy cross-examination.
Mm-hmm.
And he sets out there Dr. G's opinion. And then comments at the end of that paragraph, the court finds evidence was balanced, measured, completely fair-minded and rooted in evidence with which she was presented. My learned friend criticises the learned judge for simply adopting the evidence. Well, if the judge agrees with the evidence, it's hard to see how the judge would then set about playing devil's advocate necessarily against that evidence if, on his analysis, and we see how he's absorbed the evidence that's before him, factors it into the appropriate legal framework and says, well, I agree with it. That is...
Well, you're going to come on to, and no doubt in due course, to deal with his treatment of risk.
Well,
In due
indeed.
course.
Yeah.
I don't want to take it off your course, but that's something we've got to come back to.
Indeed. Dealing with the issue, though, of whether there is absent analysis, my learned friend in her skeleton argument, and she sets out the role as addressed by, I apologise, I think I've taken the wrong document, it's Re-H and W. It's a paragraph 52 of my learned friend's skeleton argument.
Okay.
Probably the easiest.
52.
52, which is, apologise, I have an internal page number, I don't think I have a bundle.
No, 52. This is where
As to the exercise,
she cites from Dame Siobhan's recent
Indeed.
judgment in the Supreme Court.
And when one considers A through E, the focus is on an objective view of the nature and materiality of any perceived error in the reasoning of the trial judge.
Sorry, where are you reading from?
Sorry, it's paragraph 52 and then C,
Yeah.
the focus. And then D and E.
Yes.
If on appeal it is found that a judge has unduly telescoped the process, not made the side-by-side analysis of pros and cons of each alternative to care order, then the likely conclusion is that the decision, for that reason, flawed and ought to be set aside. Well,
I don't think I shall be, for my part, I don't think telescope is the, it is a verb. I don't think it's the verb I should use for this judgment.
And it's a microscopic, far from telescopic, review of all the evidence. And we would say that...
So if it is on appeal, it's found the judge has unduly microscoped the print. I've never heard of microscope as a verb, but now I have.
But it's a microscopic, and we would say it is in such detail that the court can't be, this court we say, can't be...
I mean, there's another cliche that's going through my mind. I have to confess. You know what it is, don't you?
I think I anticipate what my lord is about to say.
I mean, that is the problem, isn't it, Woodford Tree, is that such an exhaustive exposition of the evidence that it makes the analysis difficult to discern, in fact, and, well, difficult to discern. Let's leave it there for the moment.
But what we would submit, my lords, my lady, is that just because there is this detailed exposition of the evidence, that does not mean that the judge failed in his analysis of it to come to a conclusion.
Of course not.
Come to.
No, it doesn't. Just the fact that there is a detailed exposition does not mean necessarily the judge failed to carry out a necessary analysis. Though it may well be, it makes it more difficult.
Indeed, and I accept that. And I don't seek to argue against the difficulty necessarily, but we say is when you look at the section that the judge specifically identifies as his analysis, he's taking what he has considered relevant and important from the evidence and then plays that into his considerations of taking from threshold onwards.
Okay. Well, I think 178, paragraph 178, I understand, for my part, I understand your submission that that's the basis of his assertion that Dr. G held the view that he puts in what he ascribes to 297. Whether that's right, I don't know. I have your point on it. You have your point on that. Okay.
If my lord, ladies, are content, if I deal with them in the order then, and I have my written skeleton document, the first ground obviously relates to
treatment of risk.
Indeed. That's why, my lords, I thought it was important just to reiterate the issue of what was conceded by the parents in terms of threshold, because that formulates the starting point for a consideration of what the risk might be.
Well, but don't we immediately get into a difficulty there? Because in Mrs. Kavanagh's submission, there's an ambiguity about the threshold document, and it's not resolved, as far as I can see, by the judge's recitation that it's an agreed position that the threshold is crossed, and his affirmation that he agrees. We don't know why. We don't know whether he simply agrees that it's correct that Dr. H said these things, or whether he thinks that they're made out.
Our submission would first of all have to be, my lord, that the judge accepted that document as satisfying the threshold criteria as worded for the purposes of C.
Yes, but the trouble is that there are all sorts of bits of the threshold criteria, any one of which would be enough. And I'm not sure, and we don't actually, it's not obvious on the face of it what the facts are that ground the conclusion, if we accept that paragraph is ambiguous.
Well, whatever the ambiguity, my lord, what we would say is that the threshold on the basis of that document, the court found to be crossed, and it was an agreed document. And it recognises thresholds in previous sets of proceedings. It echoes the same levels of risk and harm, and it is accepted by the parents when it comes to the consideration of long-term planning for C. And of course, the threshold is not just a freestanding set of concessions. It is the fact that only making a care or supervision order is satisfied that the harm or likelihood of harm is attributable to the care given or likely to be given to the child. So that is a recognition that the threshold is crossed, either or both, harm suffered or likely to be suffered. And clearly in this case, given that C was in her parents' care, receiving good enough parenting, it's likelihood. It's what is the likelihood of harm on the basis of what was before the court as the agreed factual basis. The judge then adds to it the parents' evidence in due course.
So you say that the agreed threshold plus parents' evidence is sufficient, is this your case? Sufficient factual basis for the finding of likelihood?
My lord, yes. Because for C, we don't have any suggestion of actual harm. So the threshold must go towards likelihood of significant harm. Without that, there is no consideration of any public law order. And that threshold, and my lord, this is not a situation where concessions or findings are made in respect of one particular issue, and then there is dispute about other particular issues. There is a recognition in that threshold of the wide-ranging difficulties that both parents have experienced, which has led to the childhood as demonstrated by the siblings. And what we say is the judge was entirely entitled to formulate risk going forward on the basis of that threshold and then the parents' evidence. He also has the expert evidence as to risk for C going forward.
Right, so his evaluation of likelihood of harm or risk of harm in the section 1.4 terminology, 2002, was based on the threshold, the parent's acceptance, and the expert's evaluation.
Yes.
What, the professional witnesses evaluation?
Yes. Evaluation of, and we know from Dr. G, that is assessment of the parents. We know that that's followed
Which
on from Mr. H.
which the judge accepted in its entirety. He said all the evidence, in a phrase that appears several times.
Yes.
Right.
That he adopts.
So that evaluation, the professional witness evaluation included, did it not, taking into account unproven allegations.
Those were clearly factored into the discussions and assessment process of the mother and the father.
And their evaluation of risk, it took those unproven allegations into account.
Well, Dr. G, I think, makes it clear that she is well aware that no findings were made, so she draws a distinction about...
Yeah, but she still takes it into account, doesn't she?
And this, well, clearly...
So insofar as the judge accepts her evidence in its entirety, he's including in that something which isn't established.
Well, what's established in the threshold, as my learned friend has highlighted in that one particular paragraph that I wait on, is the parents' acceptance. They are not in a position to safeguard C. Safeguard C from what?
Now that was Mr. As my lady pointed out, that was what Mr. H said.
But it's accepted by the parents as satisfying the threshold.
No, the paragraph says this is what Mr. H found in his report. It doesn't. It does. I'm not myself yet persuaded that means the parents accepted the contents of those paragraphs.
And it's these parents too, all the difficulties they have.
Well, I don't think there's any suggestion in either any of the cross-examinations or the evidence that the parents were not, or rather they were disadvantaged by the difficulties they had in terms of assessment.
Okay.
Everyone was acutely conscious of how to
All right.
proceed with that. But if it's simply a case of the threshold has been crossed unchallenged on the basis of what experts say, and it's not accepted by the parents, that leads us into the evidence of Mr. H, where he stresses that work to be done, work to be successful and effective, there needs to be some recognition by the parents of difficulties that have been experienced in the past. And one of the things that both Dr. G and Mr. H identify is the fact that the parents do seek to deflect any responsibility.
Yes.
For different references.
Well, that's obviously a factor. It's 1 o'clock now. We'll rise now and resume at 2 o'clock. Thank you very much.